from doing some action, which is prohibitory. And those that seek also to prevent some action, which is fair, may be performed in future. There is the need to distinguish between the various types of injunction. Like I said, you can classify injunction as prohibitory, mandatory, or coercive. It is prohibitory if it prohibits you or refrains you from doing certain things. It is mandatory if it enjoins you to do certain acts. For example, if an injunction is granted to prevent the installation of another, or if an injunction is granted to you to go and pull down a building that has already been injunction, the court has the power to do any of them. A mandatory injunction is granted where a suit has resorted to self-help and dependency of a suit to force what you call a fait accompli court, or he has completed an act. In instances, the party in the suit can you hear me?
Yes, we can hear you now,
Can the
sir, but
class
we
hear
lost
me?
you for a minute.
Hello?
I'm sorry, you went off for a while, so we could not hear you, but we can hear you now.
Hello? Well, it's not me, it's the network. It's the hear me now. It's the network, it's not me. Now I said that Joshua classified into mandatory, which requires you to do a specific act, or it could be prohibitory, which prohibits, or it may also be granted to prevent. And I'm going to do all those things for you, demonstrate them to you. A mandatory injunction is usually granted where a party to a suit, a party who is a suit, has resorted to self-help and dependency of a suit in order to force a fait accompli on the court, or he has completed the actionable wrong. In that circumstances, a mandatory injunction will be granted to undo what he has done in order to protect the integrity of the court or to protect the right of the applicant. In most cases where court will grant an application for mandatory injunction, they are usually granted either to protect the integrity of the court or to protect the rights of the applicant. And I'll give you a very practical example. Two people are fighting over a portion of land, and one of them started building on the land while the case is still in court. If the court did not give an order at the end of the day, what will happen? The going to court will be used. If at the end of the day, the party who has gone to court is the successful party, is it going to stage? The court can grant an order restraining the party from to destroy what he has already put on the land. And this has happened in many cases. I want you to see the case of Attorney.
Sir, please, we can't hear you, sir.
I think I'm having problems with internet, and I'm on campus. If the network is not good where I am, and that's where the network will be okay, because I'm using direct optical fiber here, not from the network. Can you hear me now? Hello, class. Can you hear me?
Yes, sir. Yes, sir. We can hear you.
Mandatory injunction will be granted where it is necessary to protect the right of the court or the right of the integrity of the court or the right of the applicant. I want you to take a look at the case of Attorney General of Anambra State against Okafor, 1992, 2, Nigerian Weekly Law Report, part 224, at page 396, particularly at page 427. Excuse me. Attorney General Anambra State against Okafor, 1992, 2 Nigerian Weekly Law Report, part 224, 396 at page 427. Nnameka Agu JSC of blessed memory said this about mandatory injunction. I must emphasize the fact that although mandatory injunction is sometimes classified as an interlocutory order of injunction, in that it may be granted upon an interlocutory application, it is a different type of injunction with its own distinct principles. It is noteworthy that in this respect, that is usually targeted upon a completed act, and the order therefore may be made. For an example, to order a building which has been erected to be pulled down if it is established that the defendant erected it skillfully in order to steal a match on the plaintiff on having noticed that an injunction was to be taken against him. If somebody knows that you are going to court, or you are about going to court, or you're already in court, and he decides to start construction on the land, the court can compel him to go and demolish that building that he has
I can't hear you, sir.
I think the thing unmuted itself. Where did you hear me last?
You were giving us the dictum of Nnaemeka Agu.
I passed that place. Okay, let me go back. Nnaemeka Agu was trying to explain the importance of mandatory injunction when he said that I must emphasize that although a mandatory injunction is sometimes classified as interlocutory injunction, in that it may be granted during upon an interlocutory application, it is a different type of injunction. It has its own features and requiring the consideration of its own distinct principles. It is noteworthy that in this respect, that is, it is usually targeted upon a completed act, and the order therefore may be made. For example, to pull down a building which had been erected if it is established that the defendant erected it slightly in order to steal a match on the plaintiff, on having noticed that an injunction was to be taken out against him. What I try to show is that when a mandatory order is given, it compels the person to go and do something that he has done, to go and undo what he has done. If you have put a building, go and remove it. I've done that before. I've gotten a mandatory order, even after judgment, that the person that built on the land should use his hand to go and demolish the property, or bear the cost that I'm going to use to demolish the property. But instead of me asking him to pay, go and use your hand to demolish the property that you have. And the court granted it. More so, when those acts were done during the course of proceedings, you will see some lawyers advising their client, don't listen to them. Just go and be building the house. Nothing will happen if you don't win court. That is wrong. That is very wrong. A notice of an injunction is by itself a restraint on the other party that do not do anything until the court hears it. But Nigerians, Supreme Court said that in the case of Ojukwu against Governor of Lagos State, 1986 Supreme Court. I can't remember the paper, but I can find it. Maybe in the course of this lecture, I can come across it. Once an injunction is filed in court, the appropriate thing is for the other party to stop. Watch what the court will say. If you continue to take steps when you have notice of an injunction, the other party who notice what you are doing can bring an application seeking for a mandatory injunction, directing you to undo what you have done, and the court will grant it. The second one is prohibitory injunction. A prohibitory injunction is the one that requires the defendant to refrain from an action, either the one he has done before or was about to do. For example, you must have heard of restraining order abroad. When husband and wife are fighting, a restraining order can be obtained either by the court, either by the welfare officer or by the wife or husband, restraining the wife or the husband from moving within the radius of the house in order to avert breach of peace. That's why you see when men are thrown out of their matrimonial home abroad, they never like it because they can't go through that certain radius. You will be seeing your house over there, but if they see you there, you may be on your way to jail. And again, it can also be given in a situation where there's a leakage of water, as you find in Ryland and Fletcher. Instead of Ryland and Fletcher waiting to sue in negligence and claiming damages, the quickest action is to rush to court to get a prohibitory injunction, restraining that person from further allowing that water to continue to flow in order not to damage his property or invade his privacy. The third category of injunction is what we call the quiet injunction or timate injunction. Quiet timate injunctions are injunction that is given in anticipation of or in fear of. Quiet timate means since he fears It is an injunction which is ordered to protect the applicant from an action which is fair may be committed in future. That's why they call quiet. That is, he has fear. When somebody has a fear that somebody is likely to do something in future that will injure his interest, he can bring an application to court to restrain the person because he felt that his rights will be affected. It is an injunction granted where no actionable wrong has been committed to prevent the occurrence of an actionable wrong or to prevent the repetition of an actionable wrong. Let me give you an example. If you hear tomorrow that they are going to install, you have contested for the post of an Oba, and you hear that they are going to install an Oba, or you are hearing the rumor that they are going to give the staff of office to the opposite candidate or candidate, what do? You sit down in your house and wait for them. What you do is to rush to court and obtain what we call a quiet injunction. That look, I have also been considered for this post too, but they have not even done any announcement. We are challenging this thing in court. Please grant me an injunction restraining them from installing the person or from even making any pronouncement in favor of the opponent, because you have the fear that the outcome may not be in your favor. If you see the case of Proctor against Bailey, which was the first time the case was first tested in 1889, 42 Charles Street Division, page 390, particularly at page 398. The term quiet means he who fears, that is, he who fears that he will suffer some harm. Therefore, an applicant going to court under the doctrine of quiet injunction must prove that unless the court intervene by that injunction, there is a real risk that an actionable wrong will be committed. If you see the handout that I'm going to give to you, you can see the case of Cofleps South Africa against Stolt Comex Seaway MS Limited, reported in 1999 through All England Law Report, page 593, particularly at page 597 to 10. See also the case of Attorney General for the Dominion of Canada against Ritchie Contracting and Supply Company Limited. 1919 appeal cases at page 999, particularly at 1005. Contrary to the categories of other general principle of equity, which require that there must be some right of the applicant affected, the quiet injunction does not require some right of the applicant that has been affected. Only that there is a risk that is likely to be affected. That's the difference. The risk that I fear that I have the probability that if this thing is done, it is going to affect me. You can bring a quiet injunction. If, for example, you have an application in court, or you have not even filed an application, you only hear that, okay, let me give you a very good example that happened in this school when we were students. In that particular year, we had that the president of the union of the student union was about to be removed. Some of us who are students then, we have our student court. We rushed to the court and said, Judge, please, we heard that the school authority is in the process of removing our school president without complying with the due process to remove. Grant us an injunction that until those processes were followed, nothing must be done to the school president. And that was granted. We have the fear. That's an example, a good example of quiet injunction. No harm has happened, but there is the perceived risk that This man, if they do not follow this rule, he may be removed. So that is when you can apply for quiet timeout. Many people don't know this, but even in Nigerian case, it has been recognized. I don't know if maybe if I update this note, I should be able to get some Nigerian cases on quiet timeout injunction, and I will use it to update it for you. Now, the third category is an interim injunction. An interim injunction is an injunction that lasts or remains in force until the name day and the date. This is generally contemplated at that name date. The applicant may approach the court by motion or notice, seeking a further order restraining the defendant or to the final determination of the substantive suit. Now, if you go to court, in interim injunction, if you get an order for quiet timeout injunction, they will give you a return date. They can say this case is further adjourned to 24th day of February 2025. That injunction lasts for that period of time. Anything after that date, unless you bring an application to extend that order is not a perpetual one. It's not the one that you hold in your hand and say, I have an interim injunction. No. An interim injunction is to last for a certain period of time until the court meets, until the court take a second look, particular day and date upon which the court is expected to take a look at the case. It is not a judgment that you take in your hand and say, yes, I've already restrained the president forever. No, that's not so. You will see the case of Trade Bank Limited against Continental Merchant Bank PLC, 1992 Federal High Court Law Report at page 89. Extraction System and Commercial Services Limited against Niger Bell Merchant Bank Limited, 2005. Company Law, Common Law Report of Nigeria at page 109. Even most of the rules of the court, particularly Federal High Court rules, also provide that an interim injunction has a lasting days of 14 days. And after that 14 days, it automatically lasts. That's 2 weeks. Ex parte. Another category is ex parte. You must have heard about ex parte, or you have read. Ex parte is an application for an injunction brought to court without hearing the other party. It is at the instance of the applicant only until the next motion day. We do this one anytime you want to apply for quiet timeout or anything. You don't allow the other party to know. Particularly, you bring that application ex parte. Ex parte is because it is the applicant, only the applicant. But that's not to say that if your opponent happens to know that you are bringing the application on that day and it shows up to oppose the application, the court cannot say because it's ex parte has no right to be heard. If you see the case of Alaafin of Oyo against Olaosebikan, whereby the Alaafin was fighting the Olaosebikan was fighting Basharun was fighting the Alaafin, and the application was filed by Sibafe Babalola. On that day when it was to be moved, even though it was ex parte, the court said since the party to be injuncted is already aware and is in court, they must be given right of fair hearing. And so that ex parte application will be converted to motion on notice. So the court will not grant it. Now, another category of injunction is called interlocutory injunction. Interlocutory injunctions are injunctions granted during litigation. These are applications granted pending the final determination of the suit. A suit can commence in 2025. It may not end until 2030. It may not end until anytime thereafter. in order to prevent the parties from doing anything that will prevent the court or forcing the court to having what you call a fait accompli, that is, you have already completed the act, the court may grant an interlocutory injunction restraining a party from doing certain things pending the final determination of the suit, that is, during the lifetime of the case. The award is based on balance of convenience between the potential harm suffered by the applicant, and if no injunction were awarded, the potential inconveniences caused to the respondent if the injunction were to be awarded. The universal definite application of has been doubted in many recent cases. Now, this is where we are going. For ex parte application, show them the general principle. My interest is to be affected. I have a right in the issue. The other party has done wrong. But when it comes to interlocutory injunction, this is what we call contentious application, because the other party will definitely oppose it. You put the other party on notice. It will come out. It will file a sole counter affidavit stating the facts why that injunction must not be granted. That locutory injunction is not an injunction you give to somebody that was called to ban yesterday, or even 2 or 3 years, who is not very vast in litigation. Because once you miss it, that's the end. You can't do anything. You wait until the judgment is delivered. Now, let me give you an example. Supposing that Ben, a member of class of beneficiary under a discretionary trust, has commenced litigation against T, the trustee of that trust, claiming that T has breached the term of the trust by deciding to pay trust money into other beneficiaries and wind up the trust. However, in the meantime, Ben, we want to ensure that he does not make those payments before the completion of the litigation. Therefore, what Ben will seek is an injunction against the trustee, which will prevent the trustee from making any such payment before the litigation is completed. Such an injunction, when granted, binding only up to the date of judgment, will be known as interlocutory injunction. If you get an order of the court against a defendant and you tell the person that, look, I see you building on my land even while we are here, and the court said, stop building, granted an interlocutory application injunction, restraining that person from further building. That interlocutory injunction will be binding until the final determination of the case. And then, at that level, anything done within that course of litigation, it would be a contempt of the court. But injunction, for that injunction to be granted during the course of litigation, you have to satisfy various elements. One, you must be able to demonstrate that you have a legal right to be protected. 2, you must be able to show that the balance of convenience is in your favor. 3, you must be able to show that there is a serious question to be resolved at the trial. It does not necessarily mean that you are going to succeed, but be able to show that there is a substantial question to be tried at the trial, to be resolved at the trial. And finally, there must be an undertaking as to the damages in the event that the applicant does not succeed at the trial. Now, every equitable remedy is discretionary. The court may or may not grant interlocutory injunction. In the case of Laduni against Kukoi, the Supreme Court, per Coker JSC, said that the law with respect to interim injunction was one of the most difficult sections of our law. And the difficulty is not because the law is recondite, but because the asserted principle of law must be subjected to all time rather amorphous combinations of facts which are perpetually different in every case. Undoubtedly, a good deal of judicial discretion is called for, and we would think that no one would imagine that such another would or would not be granted as a matter of course. Interlocutory injunction is not granted as a matter of course. You must be able to prove sufficient fact, to provide cogent, credible, and sufficient fact before the court to enable the court to exercise that discretion in your favor. And some of the points that you need to show for the court is that the balance of confidence is in your favor. 2, you must show that there's a serious question to be resolved by the trial. 3, you must show you have a legally existing right, the right that is recognizable in law, that is, you have the locus to bring that application. And finally, you must give an undertaking as to damage. I will enjoy students to read this case where Supreme Court clearly elaborated the principle that governs the grant or refusal of an interlocutory injunction. The case of Obeya Memorial Hospital against the Attorney General of the Federation, reported in 1987, 3 Nigeria Weekly Law Report, part 60 at page 325, particularly at page 340. Also, take a look at the case of Kutoye against CBN, against Savannah Bank. I'm coming, I'm trying to get the Kutoye against CBN. It's reported in 1989, 1 Nigeria Weekly Law Report, part 98, particularly at page 419. Those 2 cases that I've given you, if you go to the library to read them, you will understand the basic principle that undergirds the grant or refusal of an application for interlocutory injunction. It is an important injunction which you can use to restrain or to compel during the pendency of a suit. There are so many cases, and you will find some of them in the note. But let me explain some general terminologies to you. What do you mean by balance of confidence? The balance of confidence is a phrase which is being used to show that a party or an applicant seeking to apply for an interlocutory injunction must be able to demonstrate to the court that if that injunction is not granted, it will not be convenient for him. The other party will benefit more. It will be convenient to him. For example, and I'm going to give you an example. Because I do this a lot of time, I file or defend. A person is. Can somebody who is
Adenka Adebayo, mute your mic.
Please, Adenka, mute your mic, please. For example, somebody is building a factory. He has employed contractors. He has spent money. And then you bring an application to stop him from further construction of the factory. Just because in the course of building the factory, water seep into your place. To completely stop the thing, the guy will resist it. And part of the argument will show is that, okay, fine, water has entered into your house, I agree. Money can pay for damages. But if you ask me to stop this work at this level, I am going to incur more inconvenience, more than you. One of the inconvenience that I will suffer is that I will have to pay pay off my laborers. I will breach contract. This factory is expected to be completed with this also period of time. If it is not completed, there are associated costs. If you look at all those costs, this is what we are going to lose. Then the balance of confidence is more in favor of the defendant, more than that of the applicant. That is where, when you are framing your affidavit, you must be able to show how, when that man is not granted that injunction, he will be seriously affected by the case, by the injunction. In most cases, most injunctions are won and lost by the balance of confidence. If you are unable to show that what you are likely to suffer if the injunction is granted or if the injunction is refused. I want to see what the court said about meaning of balance of confidence. After I explained to you in a very simple manner, but I want to see if there's a quotation. Yeah, look at it. The extent to which disadvantage to each party will be incapable of being compensated in damages in the event of succeeding at the trial is always a significant factor in assessing whether the balance of convenience lies, and if the extent of the uncompensated disadvantage to each party will not differ widely, it may be improper to take into discount in tipping the balance the relative strength of each party as to be by the affidavit and dues on the hearing of the application. It should be unwise to attempt to list all the various matters which may need to be taken into consideration in deciding where the balance lies, let alone to suggest the relative weight to be attached to it. This will vary from one case to the other. It is not the function of the court at this stage to try to resolve conflict of evidence. Rather, these are matters to be dealt with at the trial. But one reason for the introduction of requiring that you should be able to show that there is balance of confidence is for you to demonstrate to the court that you will suffer more injury if that injunction is not granted. If you are unable to put facts to show that, the court will not grant you, because the question is, if I grant this injunction, what are you going to benefit from it, or what are you losing if I refuse it? If a lawyer cannot answer it by one word, he has lost the case. Now, you must be able to show, in addition to showing the court that the balance of confidence is in your favor, you must also be able to show that there is a serious question to be tried at the trial, to be resolved at the trial. The implication of this is that if you are going to court, I was sometimes in Supreme Court. They asked the lawyer, said, come, if we grant this appeal in your favor, what is the contribution of this case to jurisprudence? What is the benefit of this case to your client? And what is the benefit of this case to yourself? The lawyer looked up, he said that we are just, those are the questions that you need to satisfy the court. Is there any serious issue to be tried? If there is no serious legal issue to be tried, then injunction will not be granted. If it is just a frivolous case that you brought to the court, and you just want the court to grant you an injunction so that you can frustrate the other party from doing that, the court will not grant it. The court must be sure, excuse me, that your case is not frivolous or vexatious, that you seriously have a dispute, a legal dispute to be resolved. If that is not shown on the face of your paper, excuse me, the court will not grant such an interlocutory injunction. I want you to take a look at the case of Oyeyemi against Irewole local government, Ikire. Excuse me, 1993, one Nigerian Weekly Law Report, part 270 at page 462. Also, the case of Oyezo against Nze Christopher Nebedumu, 1992, 3 Nigerian Weekly Law Report, part 229, at page 315, particularly at page 316, where the Supreme Court affirmed this position that it is not the law that the applicant must show a prospect of obtaining a permanent injunction at the end of the trial. All you just needed to show to the court is that I have a serious legal issue to be resolved by this honorable court. It is not a case that you just want, like some people say, take him to court. You don't even know whether your right is okay or it's not. You don't even know whether the person have any right or any serious issue to be resolved. If that is the case, the court will not grant an interlocutory injunction. There must be damages, undertaking as to damages. The essence of that is that if you deprive the other party from undertaking the act that you are restraining him from doing, then you must be ready to pay damages at the end of the day. So you must give an undertaking in your affidavit to show that the application is not frivolous and you are willing to compensate for the injury complained about. That is the requirement of the law in relation to interlocutory injunction. Before I move further, can I ask, do you have any question for me? Do you hear me? Because I'm going to the details now. Class, are you hearing me?
Yes, sir, we can hear you.
Do you have any question for me before I move forward?
Good morning, sir.
Good morning. Yes,
sir,
I can see Deborah. Is that Deborah?
Yes.
Up there?
Yes, sir. Yes, sir. Can you hear me, sir?
I can hear you loud and clear.
Okay, please, I wanted to ask if what you were saying was convenience or confidence.
Convenience. Balance of convenience.
Okay, thank you, sir.
That is, you must be able to show that it is more favorable for you to be granted than the other party. If the other party is likely not to suffer so much injury, then the balance of convenience is in your favor. You have to suffer more if that injunction is granted, or if you are not to suffer if the injunction is refused. That's what you have to show to the court. I move on to the Maravia injunction.
Excuse me, sir.
Can you raise up your hand so that I can recognize you?
Yes, I raised my hand, sir. My name is Esther.
Esther Udo.
Yes.
What's your question?
Yes, sir. You mentioned that an interlocutory injunction binds up to the day of judgment. So I was wondering, what if the
Bind what?
judgment
I
date?
said what?
It binds up to the date of judgment.
Yes.
Yes. So I was wondering, what if the date of judgment is moved? In the case, in an event that date of judgment is postponed, does the interlocutory injunction automatically move?
Until the judgment is finally delivered, that interlocutory injunction subsists.
Okay.
If it's moved to Jesus Christ will come, that day that Jesus Christ will come, that interlocutory injunction is still subsisting. You can't do anything contrary to the court order. Otherwise, you'll be charged for contempt of court. And that's the other things too. The person will go to jail. I have cases like that. I do it. I bring people. Once you disobey the court order, the next thing you see me, I'll file contempt proceedings against you. You are going to jail. Any other question?
Yes, sir.
Yes, sir. My hand was raised.
I can see. Don't always use your name. Don't use your number. Who's this person raising?
My name?
Disu.
My name is Aisha. Yes, sir. So, sir,
Can
I
I hear
wanted
you?
to. Yes. I wanted to clarify the part about balance of convenience. So,
Yeah.
what I want to clarify is it that the test is that the claimant's or the applicant's case, or rather what the applicant will suffer if he's not granted, must be higher than what the other party will suffer, or just
Yes.
that the other party, so for instance, where what the other party will suffer is equally onerous, right? It's something that is equally as
Yeah.
bad. But
Now,
let's just say the balance is just a little more tipped towards that of the claimant. But each of them
it's
will
a,
actually
it's,
suffer guilty. Would
it's
it
an
be granted
imagine,
in that situation?
Mr. What's your name?
Aisha, sir.
Aisha. It is an
Yes, sir.
imaginary scale. The judge will put the thing in an imaginary scale and say, okay, let's tilt this scale. Which evidence is most probable, cogent, relevant? After weighing that, we see if we tilt this thing, which one is the balance of who suffers most if I refuse this injunction? If the balance of confidence is in favor of the applicant, that is, he will suffer more if that injunction is not granted. The court will grant that injunction. The balance of confidence is in his favor. And every applicant going to court must be able to show that, you know, grant me this injunction. If you grant me this injunction, I will be more happier. The loss or the injury that I'm trying to prevent is better prevented at this stage than allowing it to happen. Because as we are now, if you allow this to happen, this will happen to me. The other party that is opposing it will say, no, I have to suffer more than you do. If the court weighs the argument of both parties and find out that it is better to give that injunction in favor of the applicant, he will. The balance of confidence is in favor. Do you hear me now?
Yes, sir. Thank you, sir. So it doesn't matter that the other party would also suffer greatly.
Yeah, it doesn't matter.
Just that the claimant
who suffer most.
Higher.
So who suffer most?
Okay.
Whose injury is more?
All right. Thank you, sir.
Good.
Good morning, sir.
Good morning. Who's on the line?
Read one, sir.
Real one.
Yes, sir.
Yeah, go ahead.
Yes,
You
sir.
have the floor.
My question is, as relates to interim injunction, you mentioned that it's not perpetual and a person can
I've never
like
taught
apply
you
for.
perpetual. I only said we have
No,
not
no,
reached
no, no, no.
perpetual.
No, interim injunction. You mentioned that it is not perpetual, but a person can
Yes.
apply for an extension of date. Supposing a
Yes.
claimant applied for an extension, but it was not either granted or refused before the date where the interim injunction will lapse, what would then happen?
No, before you apply for an extension of interim injunction, the interim injunction may be about to last. If the court did not grant you that injunction or for one reason or the other, if the rules of the court sometimes provide that it lasts for 14 days. After that 14 days, it's no longer effective. But once you have an application before the court, the other party too will be more careful. You will not do anything because an application before the court is also as good as you have already made an application. Whether it will be given or not, it's a different case entirely. So what we do in practice is that when you receive an application for injunction, a good lawyer, I'm not talking of Agbero lawyer or those who do not believe in rule of law, with advice of mine, please wait. Let's go and fight this matter in court. We will still get to the same thing. Don't do anything that will make the courts not to grant you that will be make the court to be angry with you. And if that is done, then that's fine. But you have to wait. You just have to wait. Okay.
Thank you, sir.
Question.
Who's there? Bakari.
Bakari, yes, sir.
Yeah, what's your question?
Talking about interlocutory injunction, you said it was based on like the balance of like a balance. So let's say during the case, the balance tilts and the defendant will suffer more damages. Can the defendant apply for an interlocutory injunction?
No. The defendant cannot apply for interlocutory injunction. Once an injunction has been granted against the defendant, it has been granted. You can't come back to say they should grant you that has already been restrained. No. Unless you can bring an application to vary the order, if it's known that that order is obtained by fraud or deceit, and you are going to show you have a lot of work to do there. That's for another day. When you come to practice, we'll teach you that. But if we have nothing to show, forget it. It has already been given.
Thank you, sir.
Okay. Okay. Can I continue?
No, sir. Good morning, sir.
Uzo,
Yes, sir.
what's your question?
Sir, please, I was trying to affirm in determining the damages for an interlocutory injunction, is this something that the court would fix, or is this something that the court would determine based on the
No,
amount
no, no,
the
no, 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 no. They don't grant damages at that stage. You just give an undertaking. That is, you give a promise that in case this injunction is wrongly granted as a result of the facts that are presented to this court, and the injunctee suffers certain injury, I am ready to pay damages. It's the requirement before it can be
Okay.
given.
But like, let's say for instance, a company like Dangote's company encroach on my land.
Yes.
And this is a multi-million naira company that is generating millions on a daily. Now, if after carrying out an interlocutory injunction, I lose, would I have to reimburse them for all the money they lost during the period of
You
the
will pay.
interlocutory injunction?
That is why you don't go to court to go and seek for an injunction when you know you have it's not necessary.
Well, would that be equitable, sir?
No, if it turns out at the end of the day, for example, now, if somebody encroaches on your land and you sought for a mandatory injunction to restrain him at the initial stage, the man wanted to build his factory there. He has built all his hope on the land that you said is your own. And the court see what you have put forward to say, yes, you are doing that. Oh, yeah, injunction. But if at the end of the day, let's say at the end of the day, they now discover that you are not the owner of the land or your title is defective, you might run into trouble. I'll give you a practical example of what happened. This one happened last year. I took an injunction against a company from holding annual general meeting. The general meeting, they have made all preparations to go ahead. We got an ex parte order to restrain them. By the time we went back to get a final order, the court did not grant us the interlocutory injunction to restrain them. So they brought an application asking for the undertaking to damages. Of course, I have an answer to that. But I'm giving you an example because if it turns out that injunction ought not to be granted in the course of this thing, you'll be made to pay for the damages.
Thank you, sir.
Yeah. You see, let me give you, I think I've quoted it in this case. If an applicant obtained the order recklessly or fraudulently, his adversary should be amply compensated for his loss by damages which flow from the undertaking as to damages. The purpose of requiring this undertaking is simply to enable the court, should it think that the justice of the case required, to recompense the defendant who has been temporarily enjoined and as it is subsequently proved, enjoins contrary to his right and finally ascertained for the damage which he has suffered. There are situations where the extraction of undertaking is unnecessary. The discretion lies with the court. So you will see that if the reason why undertaking as to damages is always required, or it's a requirement of interlocutory injunction, is that if that injunction is wrongly given or is based on fraud or misrepresentation, then you will be made to compensate the party who has suffered injury unjustly as a result of the interlocutory injunction. Shall we proceed? Can we proceed now?
Yes, sir.
Good. The next category of injunction is the one special injunction called marital injunction or freezing injunction. I'm sure you have heard many times where they say AMCON has frozen the asset of a debtor. Which application did they take to court? They usually bring application for Marital injunction or a freezing injunction. A freezing injunction or a Marital injunction is usually awarded to prevent the respondent from removing assets from the jurisdiction of the court before the completion of litigation to avoid settlement of a final judgment. Now, if you have a case in court and you know that to recover money or an asset somewhere, that you know that the person can dissipate or move out of the jurisdiction of the court, instead of you to wait and get judgment of the court and start proving that I have nothing to enforce, while the case is going on, you go and bring an application called Marital injunction ex parte to restrain that party from moving that money or asset from the jurisdiction of the court. The application you bring to the court is called Marital injunction. And that case, and that Marital injunction is given in the name of the case where it came from. Marital Companion Navera Sat SA against International Bulk Carrier SA. 1995, 2 Lloyd's reports at page 509. Today, it is now known as Asset Freezing Order or Asset Freezing Injunction. Instead of calling it Marital, they call it asset freezing. You freeze the asset of the respondent from taking it out of jurisdiction. All his bank accounts, ensuring that the money did not leave the account or the asset did not leave the location in which it is. If you know that somebody has movable asset that it can move from one place to the other, you just get another in the warehouse. Say, hey, stop, all the assets in this property should not be moved. Supposing a Venezuelan dealer has sold a painting, which a representative was an original version of Daily Girl and Window, to a B England company for 3 million. In the event that it turns out that the painting is a fraud and was painted by an art student from Bermondsey, although it looks good, it is worth $5,000. Assuming the student has no money, B will sue A for the payment of 3 million on ground of breach of warranty and fraud. The risk is that A will remove all his assets from the jurisdiction by emptying the bank account and selling all other property held in Lagos or in Nigeria. The remedy which B will want up to the date of judgment and until the judgment is satisfied is an injunction to prevent A from removing any asset from the jurisdiction. In effect, the asset of A should be frozen. This is what is called freezing injunction. That's what AMCON normally do. But for a Marital injunction to be granted, there are 3 requirements that must be satisfied. 1, the applicant must have a good case. You must be able to show that they have a good case against the applicant, against the respondent. 2, you must be able to satisfy the court that the respondent has an asset within the jurisdiction of the court. And 3, you must also be able to show that there is a real risk of either dissipating the asset or secretion of those assets, or is likely to take it out of the jurisdiction, which will make the judgment, if granted, a good case. If you don't have a good case, they will not grant you. 2, you must be able to demonstrate to the court that the asset of that person is within the jurisdiction of the court, not outside the jurisdiction. If the asset is in Ibadan, you can't go and get Mariba injunction in Lagos. No, you go to Ibadan where the asset is within the jurisdiction of the court granting the order. But if it's a foreigner, you can get it if it's a federal high court matter. The federal high court is single. Anywhere in Nigeria, you can get it. But if it is high court that has limited jurisdiction, you must be able to, the asset must be in the location of the court. 3, you must be able to demonstrate to the court that if we don't do this, the respondent will dissipate the asset or will take the asset out of the jurisdiction of the court, and the judgment of the court, if eventually you win, will just be a fiery victory. You have nothing to show for it. And therefore, you get an order of the court for that. You must show, once you are able to show that, then the court will grant you a Mariba injunction. The other type of injunction usually used is what is called a Tompila injunction or a search order injunction. Let me give you an example. Supposing you are doing a case and the document you wanted to use to prosecute the case is in the hands of your opponent and is about destroying, or you have the fear that he might destroy the document, or he might move it out of where he is, or by the end of by the time the prosecution begins, those things will have been destroyed. Let me give you an example. If somebody pirated the work of another person, the Alaba boys that are good for pirating, if they pirated the work of somebody, and those works that you needed to show as an evidence in court, they are in their warehouse or somewhere, how do you know them? How do you get those things? They are in their possession. There is the possibility that they can throw it away, they can destroy it, they can do anything. 2, if you are enforcing a breach of a trademark, which somebody has infringed your goods or product and is selling it in Kano, and you happen to know that it is stored in the market, in a warehouse, or it's being sold in this particular market, those are the evidence you need to show to the court. What you can do is to bring an application to court to seek for an Tompila injunction or a search order injunction, which will entitle the applicant to seize the defendant property to project evidence in relation to any future litigation. This order will be made on the satisfaction of the 3 criteria. There must be an extreme strong prima facie case against the defendant. 2, the potential or actual damage must be very serious for the applicant. 3, there must be clear evidence that the defendant have in their possession incriminating documents or things with a real possibility that they may be destroyed before an application could be made to the court. If you are unable to show that, you are not likely to receive the order. The case of a Tompila injunction or search order is named after the case itself. A Tompila injunction is named after the case itself. A Tompila KG against manufacturing processes. It is reported in 1996 Chancery at page 55. In that case, Lord Ormrod stated that there are 3 essential preconditions for the making of such an order. First, there must be an extremely strong prima facie case. Secondly, the damage, potential or actual, must be very serious for the applicant. You that you are going to court to say that your right has been infringed, or your trademark has been infringed, or certain document, you should be able to show the court that, hey, My Lord, if you did not give me an order to go and sack this place, my whole right that I'm about to enforce will be affected. And I have the fear that if I don't have this document, I will not be able to succeed in proving my case. That's what usually trademark people do. They just get this search order. Enter your factory, check all those infringing or offending documents from the or documents or equipment or any tools that they require, and that will be all. Thirdly, there must be clear evidence that the defendant have in their possession incriminating document or objects or things. And finally, there is a real possibility that they may be destroyed before any application inter parties can be made. The decision of Long International PLC against Bestwick and other, reported in 1989, One Weekly Law Report at 1268, also reaffirmed this position. Do you have any question for me on those two injunctions before I move to the last part, and then we end the lecture on interlocutory on injunction generally? Class, do you have any question for me?
Yes, sir. I have a
Yes,
question.
sir. Good morning, sir.
Good morning. You need Bernice.
Yes, sir. Sir, is this Anton Pillar injunction, sir? I don't think I understand it yet. And I didn't get the actual case, the Anton
Don't
Pillar
worry.
case
Don't,
that you
don't
mentioned.
worry. I will send you the handout after this lecture.
All right, sir.
Now,
Thank you, sir.
when freezing order, when you say freezing order, a searching order, Anton Pillar is named after Anton Pillar injunction is named after the case itself. Anton Pillar against what's the name of the case again? It's a very long name. Anton Pillar. Just a minute, give me time. I'll be able to look at it from. I don't remember. Anton Pillar KG against Manufacturing Process Limited. That is the name of the case that established the principle. And what does it mean? An Anton Pillar injunction is an injunction or an order asking you to search the property or a location of the respondent with a view to bring out certain evidence which you have the fear that may be destroyed before parties approach the court. You get me now?
Yes, sir.
Do you understand? And I give you a very good example. If, for instance, somebody infringed, it's very good. Those of you copied my books. Supposing somebody went and made photocopy of my environmental law textbook and made them, kept it somewhere. And I had information that, Prof, you see that environmental law book, somebody had copyrighted the book by making photocopy and selling it at a cheaper price. And they tell me, you think I'll just sit down and be smiling? No. They told me that the book is kept in Faculty of Law warehouse. I said, okay, fine. I will go to court, bring an application, freezing order, Anton Pillar order, asking me, granting me the order to search the warehouse where those books are kept. Because if they do not allow me to do so, this guy can take this book either out of the jurisdiction or he can destroy it. And that is my evidence against him. The court will grant me an order. And but for me to show that, I must show that I have a right. Two, I must also be able to show that I have a strong case, a strong prima facie case in court. And that case is the case of copyright, breach of copyright. Three, I must be able to show that those things are in his possession and is likely to destroy it. I have the real risk, probability that he will destroy it if he knows that I'm taking this step before both of us are taken to court. The court will grant it. Yes. Is that clear? Can I continue?
Yes, sir. Thank you, sir.
Good. Finally,
Sir, I have a question.
Oh yeah, ask your question because the time is almost. Yes, what's your question?
My question is as regards Mareva injunction. So you stated that you have to bring the application for injunction within the jurisdiction where the assets are located. And you
Yes,
also mentioned that a Mareva injunction can be brought ex parte. So my question
yes. It's
is, what?
usually brought ex parte. You don't.
Okay,
You are going to inform your opponent. No, it's usually brought ex parte. You
okay.
are not
So
supposed
what?
to inform your opponent.
Okay, sir. So what if the respondent has assets in a multiplicity of jurisdictions, say probably like 20 jurisdictions or something? Will I have to
What
apply?
if the what? If the
What
asset
if
is
the respondent
if
has
what?
assets in many jurisdictions,
You
different
go to
jurisdictions?
those jurisdictions where those assets are. For example, if you know that your opponent has money in America, and you are pursuing against him in Nigeria, and that's where he kept all the money, you go and freeze the account in America or in London, not here in Nigeria. You can't freeze an asset that is not within Nigeria. You freeze it within the jurisdiction where the assets are.
So if he has in 50 jurisdictions, I'll go to 50 jurisdictions and freeze all his
Not be
assets.
not be you won't collect money. Yes, go to those jurisdictions. Hey, you
Okay.
think it's very easy. Why will you it as a lawyer? If they have to take one order to take care of 50 jurisdictions, what will happen to other 50 lawyers in those 49 lawyers? Eh? Don't know that
Mm,
sometimes we do this thing to preserve our economic interest too. Now
okay,
let me
thank you.
proceed. Perpetual injunction. Then I can take other question. Perpetual injunction is the ultimate of injunction. This is an injunction granted after the parties have been fully heard. A perpetual injunction is intended to settle finally the relationship between the parties in connection with the matter in dispute, so as to relieve the plaintiff from further bringing series of action as his rights are from time to time infringed by the defendant. A perpetual injunction is directed towards the final settlement and enforcement of the rights of the parties which are in dispute. I want you to see the case of Adeniran against Alao, 1992, to Nigerian Weekly Law Report, part 223 at page 350, particularly at page 372, where Nikki Toby, JCA, as he then was, noted that while a court of law can grant an interim injunction ex parte in exceptional cases of extreme urgency to preserve the rest or status quo, and while a court can also grant an interlocutory injunction where the applicant, among other things, shows the existence of a legal right and the need to protect that right. The relief of perpetual injunction, as the name itself implies, is the largest of the three reliefs. Put it in another language. An interim injunction stops where an interlocutory injunction begins, and an interlocutory stops where a permanent injunction begins, where a perpetual injunction begins in perpetuity. Perpetual injunction cannot be granted on speculation or conjunction on the part of the trial judge that the plaintiff seems to have proved his case. This is because, by the very nature of perpetual injunction, of the finality, it can only be granted if the plaintiff or the claimant has successfully proved his case on the balance of probability or the preponderance of evidence. In other words, perpetual injunction is granted at the end of the proceedings, where the plaintiff is able to demonstrate that he has entitled to those rights by providing credible and cogent evidence on balance of probability. Once that is done, When you can grant ex parte injunction by just mere rights, you cannot do so without hearing the other parties, and you must be able to show. For there to be perpetual injunction, the grant of perpetual injunction, the case must have been concluded. 2, the party must approve this case by preponderance of evidence. It is also discretionary in nature, like any other equitable jurisdictions, equitable remedies. The plaintiff must show that damage will result to him in future, and must also show where such damage occurred, the award will not be sufficient. The plaintiff must have established to the satisfaction of the court that is entitled to the right which it seeks to protect by injunction. Usually in declaration of title to land, when the judgment is in favor of the claimant or the plaintiff, a perpetual injunction will be granted in favor of the claimant to show that he has rights over that land, and it will constitute ex officio rem judicata against not only him but also other members of the family. Once an injunction has been granted and has been sustained against a defendant, it's not only binding, it also binds his successors in title. A perpetual injunction exists in rem, even against the whole world, once granted, and it settles the question of dispute between the parties. Do you have any question for me? On that note, that is the end of the class. If you have any question, you are free to ask.
Yes, sir, I have a question.
Go ahead.
Good morning, sir. Sir,
Good morning.
under Mereva injunction, that is the freezing order, we recall that one of the maximum of equity is that equity acts personal, that is, equity acts on the person, not. But on Mereva injunction, I believe it's given to freeze a particular asset. So I want to get a clarity on that too, sir.
It's given to freeze the asset of a particular person.
Yes, sir.
It's not to freeze an asset. It's to freeze an asset of a person.
Oh, okay.
Somebody owns the property. When you say in personal, against the person of that person, of the person involved, as against rem. Rem is against the whole world. Against the whole world, meaning including the third party. But this time around, it is against the asset of the defendant. Any other question? Good.
Good morning, sir.
Good morning, Tosin.
No, it's Mary. Sir, please, I didn't get the second requirement you mentioned for perpetual injunction.
Perpetual injunction. What is the first requirement that I mentioned?
That the case must have been concluded.
And the party must also have established its rights.
Okay, sir.
By preponderance of evidence. And that it must also show that the damage will not be sufficient if the injury further occurs in future. There are many requirements, about 4. If we get the handout, we will see them there. Any other question? Well, it's nice talking to you. If you don't have any question for me, it's almost 2 minutes to the end of the time. This is the end. This will be the end for interlocutory, for injunction generally. Class governor, when can I send this article to you?
You send it to
Class
my
governor,
WhatsApp, sir. You can send it to my WhatsApp, sir.
I don't know your WhatsApp number now. I don't know
Sir,
your.
I sent you the link
What's your
last
name?
night.
What is your name?
My name is Sheyi.
Did
I
you?
communicate with you on WhatsApp, sir.
I don't know.
I
Okay.
still sent you the link yesterday night.
I didn't store your name because I don't have your name. So
Okay. Okay, sir. Let me text you now, sir, again.
I only use I only use the information you sent to me, but I never store your name.
Okay, sir. I'm going to text you now. Okay.
Not necessary. I'm sure if you are checking your mail, you will see it in a second.
Okay, sir.
Can you confirm receipt?
Received, sir. I've received it.
So class, I've given you the handout on that.
Thank you, sir.
So on that note, we meet again when?
On Tuesday.
When is our next class? On Tuesday, what time?
Tuesday, sir.
What time?
12:30, sir.
10:30.
12:30 p.m.
12:30 p.m. Hello,
Yes, sir.
12:30. 12:30. Okay. See you then.
Thank you, sir.
Thank you, sir. Bye-bye, sir.